Good morning. May it please the court. My name is Michael Abbey and I represent the appellant Crystal Kapla-Denofa. I'd like to reserve 5 minutes for rebuttal. This is a fairly straightforward appeal from an order enforcing a supposed settlement agreement. The genesis of that settlement agreement was an oral offer conveyed on the day of mediation during the Zoom mediation session by the mediator, retired Judge Greg Holder, and it was undisputedly not reduced to writing, signed by the parties and their counsel. Yes.
Doesn't this case turn on whether the mediation had ended in order for the rule to apply and the requirements of the rule to apply? The operative question is, had the mediation terminated or ended before the offer was made? Am I right?
I think that's correct, Judge LaBritte. I think there are follow-up reasons why we would win even if mediation had not been found to have ended, but I think that is the main issue.
Of your primary argument,
correct,
which is based on the rule either applies because the mediation is ongoing or it doesn't because the mediation had ended.
That's correct.
And the statute says that the mediation ends, among other, one opportunity for a mediation to end is when the parties have agreed. And getting to my question, the evidence in this record is trial counsel's statement to the court, which arguably is under oath as an officer of the court, that the mediation had ended. Mr. Pimenta's affidavit saying that he believed the mediation had ended. And your client, who said she didn't reach an agreement during mediation, apparently she authorized her lawyer to make an offer and develop some offeror's remorse. But the only evidence in front of the trial court of whether the mediation had ended or not are those three things. And if the trial court resolved that factually in favor of the mediation having ended, what do you want us, where does that leave you in terms of, does that leave you with your second argument?
No, Your Honor, and I don't think that that's all that was before the trial court, and I'll go into that. But I think the issue of what happened, the factual issues are not in dispute, but whether or not that rises to the level of an oral agreement to end mediation, or I'm sorry, the statute doesn't provide for oral agreement, for an agreement to end mediation is a question of law. What we do have here factually is that the parties were never in communication with each other, that apparently, while they were in separate mediation rooms, they somehow reached an agreement, and then yet still the offer was conveyed through the mediator, retired Judge Holder. There is no evidence that the party...
One way of looking at the agreement that they reached on, is that the mediation had then passed. And you all are, you practice in civil personal injury. You've all been in mediations with insurers and multiple defendants. Obviously, I think it's undisputed that the parties were close. And at least in the 35 years that I practiced law, it was not terribly uncommon to, after a mediation impasse, one side to say to the mediator, before we all go home and you send us your invoice, would you find out if that last offer is still alive? And give us a couple of days, we'll take a couple of days to think about it. Isn't that kind of what happened here?
Well, respectfully, Your Honor, I don't believe that is an end mediation. If you're at mediation and you're saying, before you declare an impasse, let me know if that offer is still open, mediation is not ended by statute. It has to end by agreement. And there could be no agreement to end here because the trial counsel were not in communication with each other. This is an ex post facto rationalization. The affidavit of Mr. Pimenta.
So let's go then to your second point. Nobody disputes that Holder went back to the defendant and said, the plaintiff will take $350.
Correct.
Global resolution you got till noon on Friday. We all agree to that, right?
That is correct.
Okay. And there's no written evidence of that. It just happened. And we know that it happened because the lawyer sends an email on Friday morning saying, we'll take the $350 and we'd like a release, give me your wiring instructions.
Well, that's not correct. We know the offer happened because of Mr. Pimenta's affidavit that said my offer, which I told Judge Holder to convey, was $350,000, a specific sum, no mention of a dismissal with prejudice, no mention of a release.
Settle a garden variety negligence case without a dismissal and a release.
Your Honor, respectfully, you could file a final disposition form informing the court that the case has settled. The reason, and I wanted to get to these cases on releases, the reason why the release language both isn't a mirror image rule and prevents a finding of the meeting of the minds is because the only cases that are cited by the appellee, and this would be Fonseca, this would be the Earhart case, the Boyko case, these cases that suggest a release is implicit. Well, Boyko, first of all, has nothing to do with the release. That's the genesis that these three cases, or the two other cases, are based on. Boyko is a case in which the court found there was an oral settlement agreement and that reducing that agreement to writing was a mere procedural formality. From that, Earhart and Fonseca extrapolate and say that signing documents are implicit as part of a settlement agreement. But those cases are distinguishable. But they are both full tender cases. The reason why that's important is because if you look at specifically the offer in Fonseca, it was, we will settle for all available limits. They didn't know what limits were available. They even said all available limits, including any possible umbrella policy. And the response back was, here is all of our limits and a release. And because it was a full tender case, the court found that, okay, signing the release, that's an implicit aspect. It doesn't violate the mirror image rule. But Fonseca itself includes at footnote 2 a warning that says, we could see how if you send us a release back, it could be objectionable. And if it is, then that would be evidence that there wasn't an agreement.
Question. What in the release that they asked for was objectionable?
They never sent us a release, which is the problem, Judge Valenti.
They wanted a full release. That's all they wanted, correct?
We do not know. Their email just says release. It doesn't say
You
full.
think the release being inadequate. Was that one of the basis for the rejection of the offer?
No, Your Honor. And let me correct that. At 8:42 a.m. on Friday, there was an email from Ms. Sisti that said, we accept settlement of $350,000. We will send you a release and prepare a dismissal with prejudice. At 9:59 a.m., before any substantive response, then trial counsel responded back saying, I've been replaced by Mr. Labby, and his affidavit states, and this is, I believe, at page 42 of the record, I then informed Ms. Sisti that PHL was taking over as counsel in this case and took no further action on behalf of the plaintiffs. So the release, even at the time of the motion to enforce the settlement.
4 days for the new counsel to object to the release? Did it take 4 days for this to happen?
No, Your Honor. No release, even at the time of this order, has ever been drafted. There's no release that we could object to. Instead, they were informed that there is no settlement immediately.
When did that?
That the email directly from us in the record, our firm, I believe that was within 4 days, saying we object to the existence of any settlement and we will set an expedited hearing. Pardon me, Your Honor?
It wasn't you that sent the email at 9:59?
That's correct. That was prior trial counsel, and that email at 9:59 a.m. Was a email received by prior trial counsel from our firm, and he then says, I then informed Ms. Sisti, PHL was taking over and took no further action. So in response to the 842 email, the email that mentions the release for the first time and a release that hasn't been drafted and the scope and terms of which are unknown, the prior trial counsel says, I took no further action. So this is the problem with the issues 2 and 3, Your Honor, is raising a release for the first time in a case that's not a full tender case. And when you haven't even drafted that release.
Full tender. I don't think the case law used the word full tender. The facts have to mention that, but the holding didn't hinge on whether it was full tender or less than full tender, did it?
It's not mentioned in the part of the case that has to do with the holding. I believe that's right, Judge Valenti, but I would posit that that footnote is in the holding in Fonseca, which specifically warns we could see how if the release would be objectionable, whatever's contained in it.
Look, the difference between a full tender case and the context in which that's going to come up is you've got multiple insurers, perhaps, that are on the hook, maybe already, for bad faith. This record shows nothing of that nature. You've got a garden variety negligence case, a few defendants, obviously one that's insured, at least. and putting a dollar figure on the plaintiff's claim. And I struggle to, I'm with Judge Valenti on where exactly does this full tender doctrine become a law?
I don't think it's a lawyer. I think it's just highlighting footnote 2, which is saying we don't know what the release is going to contain. If there's one plaintiff.
But in the garden variety, plaintiff versus defendant, all of whom are responsible for the irrigation system, one way or another, derivatively or directly. The full tender is sort of a red herring because her injuries are worth what they're worth. Whatever the coverage issues were not developed here if there were any. So I'm seeing it as a red herring, but I don't want to derail you too much. You got about 4.5 minutes left on the main.
I would just say I respectfully disagree, Judge LaBrue, because we don't know from the record, and we don't know because there was no release drafted. Is this going to be releasing claims of other parties, a potential claim for loss of consortium?
So really, you just said to me that the appeals agreement showing that issue. You don't know what was in the release. How can you object to what wasn't in the release if you don't know what was in the release?
And that is exactly my point, Judge Valenti, that I can't even.
What I mean is, you go back and they want this crazy release that releases the country of Hungary. Then I say, I object. Well, maybe you have a different story, but we don't know. Who's the burden on the appellant or the appellee to prove one way or the other? Well,
the burden below is on the party seeking to enforce the settlement agreement that there was a meeting of the minds as to all essential terms. Here on the appeal, it would be my burden to demonstrate that there, in fact, was not a meeting of the minds, I guess, as to all essential terms, or that the trial court erred in determining so. And based on this record, I think that is clear. How could the trial court, which ordered my client to execute a release that still hasn't been drafted, what is my client going to be signing? What rights will they be giving away? The trial court.
Limited time, so if you have something to say, please.
I'd like to go back to issue number 1. Issue number 1, I think, is most critical here, which is, again, the conclusion of mediation. The statute says mediation after attendance, after satisfying your attendance requirement, may be ended by agreement. I think it would be.
Satisfying of the attendance requirement is the part about sending warm bodies that have authority to do things and jumping through the hoops of submitting that paperwork to show that they're coming, right?
Yes, I understand, Judge LaBrue, but this is where it becomes a problem. If you are attending mediation and you're saying that we reached an agreement, even though we never spoke to each other at mediation, to end that mediation, we deposed trial counsel for the insurer below, and they objected and refused to answer any questions, this is in the record, in that deposition about what occurred at mediation, which would include reaching of that agreement. So they won't answer any facts or any questions about what agreement was reached, what communications were exchanged that would suggest there was an agreement to end mediation. But then they want to use that as both a sword and a shield and say, well, we reached a secret agreement at mediation that we're not going to tell you about, even though we weren't communicating with each other.
It seems to me that a piece of evidence that isn't here, but could have been, would be what would Judge Holder have had to say about this. But that's not the record that you have.
That's correct.
And the record that you do have has a general tenor, at least to one woman's way of thinking, that doesn't contradict the notion that the parties all understood. Mediation had ended. Holder's off the clock. We're going home. We don't have a settlement. And on the way out, the defense lawyer says, can you before you put your invoice together, but now that we're done, we're going home. Mediators do this all the time. Is the offer open? Just let us know. The last offer they made is open, let us know.
If I could address that briefly, Your Honor, if that happens, then mediation hasn't ended because one of the 4 statutory parameters hasn't happened. And I think it would be a mistake for this court to find that.
Are you mediating if you don't have a mediator anymore? If the mediator puts the offer on the table, if the mediator confirms that offer is still out there, and then the mediator rides off into the sunset and the parties are left to hash it out, do we still have a mediation ongoing? That
is not what happened here, Your Honor.
How do you know?
Because the record shows the only undisputed fact in the record is that the offer supposedly accepted.
In the way of mediation, after the holder confirmed the availability of the offer that was left on the table by the plaintiff.
Nothing happened in or outside the mediation, Your Honor, because the mediation hadn't ended. The only facts are the mediator conveys an offer,
so
it's an email back.
You want to hardline the rule that if an offer is made during mediation, some days later is resurrected and accepted, then the mediation is ongoing.
No, Your Honor, that's not what I'm asking for, because here that's not what happened. There was no resurrection. If I can get to my final point about this mediation rule, the problem is twofold. Under Rule 1.730B, any argument or any agreement at mediation, partial or full, must be reduced to writing. And I posit that that would also include an agreement to terminate mediation. Secondly, if this
Well,
court,
let's say you wanted it to be in writing, they knew how to tell us that, and that's not what the statute says.
respectfully, Your Honor, if this court is to rule that you can reach an oral agreement at mediation to terminate mediation, you've gutted all the protections of the writing requirement in 1.730B, because just as in this case,
Your rebuttal, you can use your time anytime you want.
yes, Your Honor.
Seconds into it.
Thank you. Just as in this case, any party through ex post facto rationalization can say, we violated 1.730B. Well, didn't it kind of feel like we were over? And that would be sufficient. Thank you. I'll reserve the rest of my time for rebuttal.
I'd like a little bit towards my help, please. Thank you.
Yeah. Excuse me.
Good morning.
May it please the court, Karen Bellis
Oh,
for the defendants.
I should have told him with my, then he moves your body to the wrong side. Sorry.
May it please the court. The trial court's order enforcing the settlement agreement is supported by competent, substantial evidence and must be affirmed by this court. Just to be clear, we're here today because after reaching a binding settlement, new counsel appeared for the plaintiff as trying to undo a binding settlement based on non-existent technicalities. Plaintiff fails to cite any case law or mediation that was found to be ongoing, where there was any evidence that mediation had in fact
Well, to
ended.
give you the equal opportunity counterpoint, right? Your opponent, your friend on the other side is telling us that the context of these facts, the mediation had not been terminated because the offer was made through the mediator and accepted by your trial counsel at a time when the mediation was ongoing, and that there had to either be a writing or a crystal clear understanding, maybe an impasse notice by the mediator, to otherwise take this out of the operation of the rule. Help us understand why that's not the correct.
Yes, Your Honor,
approach.
and the evidence actually demonstrates, and the law provides, that mediation can end by agreement, and that's exactly what happened here. 3 pieces of evidence: Mr. Pimenta's former trial counsel's affidavit, the plaintiff's own affidavit, and Ms. Zisti's deposition testimony, as well as what happened at the hearing. The timeline clarifies what happens along with these 3 pieces of evidence. On Tuesday, January 30th, again, there's no contest that Mr. Pimenta represented the plaintiff. They attended this Zoom mediation. Mr. Pimenta testifies in his affidavit that they were unable to reach a resolution at mediation. It was his understanding that the mediation had reached an impasse. And then he testifies in his affidavit that after telling the mediator that plaintiff will not accept plaintiff's last offer, both he and the plaintiff herself requested the mediator convey a time limit demand, which contained 4 terms: a global demand, a time limit until Friday at noon, for plaintiff to settle with all of the defendants for $350,000. This is at page 40 to 43 of the record. Plaintiff's affidavit also confirms that she did not reach or sign a settlement at mediation, and she confirms that this global offer was made by Mr. Pimenta with her authority. And then,
Now, she does say in her affidavit that she never reached an agreement to terminate the mediation. I think that's at paragraph 16, am I right?
yes, Your Honor,
And what's your position on that?
it's a self-serving statement that is completely contradicted by the way mediation happens. The way mediation happens at Zoom and both lawyers' testimony. As this court has recognized, offers often go back and forth. Everyone agrees to end mediation. And Ms. Sisti's testimony also is that this offer happened outside of mediation.
Let me ask you a question, and I would like your friend on the other side to address on rebuttal. Is it more or less consistent with the fundamental policy of our state, which is to encourage and enforce, whenever appropriate, settlement agreements, to take a rigid view of when a mediation is terminated for purposes of whether the rule and its special requirements apply? Which approach is more consistent with our state's policy? Tell me.
It would be more consistent to look at the evidence that mediation had ended and enforce a settlement. Because settlements are often enforced and
what about if we go to step 2 or point 2 here, right? Which is, do we have evidence of a settlement sufficient to enforce? I think one of your opponent's primary points is we didn't have a release, so we couldn't know what it was going to say, and we didn't have a mirror image, but mirror image not applicable, but we never saw a release. And it could have said anything, release the entire United States and everybody in it from everything. And so we didn't have a meeting of the minds. I think that's effectively what he's arguing. And it's true. Like the email that your trial counsel sent here's the release, just says, we'll take a release and a dismissal and give us your wiring instructions. So how do you counter the lack of any sort of documentary evidence of the settlement terms?
the release is implicit. This is a basic personal injury action, a global
What
demand.
about his theory of I lost the doctrine of full tender? Tell us what your position
The
is.
case law repeatedly cited in our briefs stands for the proposition that a basic release is implicit. A release is, nobody would pay money.
You had at least 3 defendants and an insurer back there somewhere, at least one. And while we don't see any evidence of a bad faith claim or a claim on an umbrella policy or something like that, why doesn't that doctrine come into play here, just given the number of defendants and the availability of coverage?
A couple reasons. The terms of the demand, again, global, all defendants settled this lawsuit, period. There's no release to object to. There's nothing that says this wasn't the terms that is the implicit, that if these people, for this $350, are still going to be $1,000.
Keep you up there for a while.
Are still gonna be liable.
Improving as you're going.
I'm sorry. I'm so sorry.
You got me this time. I'm sorry to interrupt.
Her statement, Ms. Sisti's statement, that a voluntary dismissal and a general release for this global settlement, this doesn't transform the release and her email acceptance to a counteroffer. The release is implicit because no one would pay this sort of money if they were going to be liable. And she also explains, Ms. Sisti explains at the hearing, that her insured's policy, team management, had been defending both defendants, but that she was the one, due to some contractual terms and indemnity terms, that her client and her client's policy would in fact be paying, again, the terms of this settlement, all defendants, and the money was going to come from. So again, this is a usual settlement document. There's nothing objectionable, and a global release and a voluntary dismissal are, as this court's recognized in MODA, part of what is part of any general settlement.
Well, would you agree with the notion that the mediation was still ongoing? That this panel is bound by our holding in the Parkland case, which isn't so far away from this one as to be laugh out loud, not distinguishable. If the evidence is such that we are not persuaded that the mediation had terminated, then I think we have to follow Parkland. So give us your best case on the evidence that the mediation had terminated within the meaning of the statute. I don't think you require a writing or the filing of an impasse, but what is it besides, I thought so, I hope so?
Well, and I would agree that the court would be bound by Parkland if there was no evidence, and there was no evidence in Parkland or any other case cited here that mediation had in fact ended by any of the terms that are laid out in 44-404, one of which is agreement of the parties. What is the best evidence? The two lawyers' testimony, the two officers of the court sworn testimony in deposition. Ms. Sisti testified to what happened after mediation, that this offer was not made in mediation. It was made outside of mediation. And she explained again at the hearing and asked to be sworn in if the court had questions, that mediation had terminated, that she asked the mediator to go back and see if the last offer remained open. And he came back and said, no, but they have a new global demand and here it is. And then Mr. Pimenta's affidavit confirms that they had impassed and that after mediation had ended, he and his client extended this new demand, which again, at 8:52 in the morning, was accepted by Miss Sisti. And only after that, and in fact, the timeline, what happened, this isn't old-fashioned mediation where you can go in the hall and talk afterward. The parties aren't together, so the only way the mediator is going out in and out of the room, and he conveyed this after the fact, after mediation had ended. But what comes after that demonstrates that the parties weren't going back to the mediator. And if this was a mediated settlement, because
So the fact that the acceptance came directly from
Yes.
defense counsel to plaintiff's counsel is an important fact from your perspective. If it had been brokered through Holder,
when
then
you're
you wouldn't have much to talk about and we probably wouldn't be here.
correct, because then it would be going through the mediator and would be part of mediation. Again, first you have the testimony from both lawyers that mediation had impassed. But then, instead of going back through the mediator, this evidence shows that mediation had ended because the parties email with each other this 8:52 offer by Miss Sisti. And then these emails go on for days. But only a week after the mediation does the new counsel actually appear and object. But within that timeline, first Miss Sisti accepts. She doesn't get any word that Mr. Pimenta has been terminated. Instead, Mr. Pimenta gets an email, apparently, telling him after this acceptance on Friday that he has been terminated. The following Monday, again, we're now 5 days later, Ms. Sisti sends an email to both Mr. Pimenta and Mr. Labby, not the mediator, stating she's been told that Mr. Labby is now representing plaintiff, but I'm sure Mr. Pimenta has told you, Michael.
And at that point, the defendant just wants the money to get wired.
She is asking for payment
Place to
instructions.
send the money.
Yes. She is asking for payment instructions, yes. And that same day, let me just play devil's advocate here. Even if her subsequent email, her acceptance email mentioning the voluntary dismissal and the release was a counteroffer, Mr. Labby accepts it again outside of mediation because the following Monday, again, her email accepting is Friday the 2nd, Monday the 5th, Mr. Pimenta, who is still plaintiff's counsel and still is counsel of record, there's no substitution here. Plaintiff's counsel, excuse me, he's still representing. He goes on to say, the case has settled at the time we represented the client. The contingency came to complete fruition. This is again after her email offering the voluntary dismissal and release.
That was right before he filed his charge.
Correct. But he accepts. So even if her voluntary dismissal and release in the email created a counteroffer, not only did he clarify that the case was resolved, he accepted these terms because he did not object to the voluntary dismissal or the release. So counsel of record, again, the contingency came to complete fruition, and please make the settlement draft out to us and we'll hang on to it while we figure this out, is essentially what he says. So you have the acceptance on Friday. The release is
So
on
the way you would characterize the Monday emails about go ahead and send us some money, we'll work it out, is sort of a ratification, even after Mr. Labby had made the scene.
Correct, Your Honor. And he further explains that the settlement is over and done. He has no objection to a release. So even if this was a counteroffer, he accepted that as counsel of record. He's still counsel of record. And this is again Monday, February 5th. And only the next day, February 6th, does Mr. Labby respond to Ms. Sisti's emails and explain that Pimenta has been terminated. And she still says, I have no letter of representation and you haven't filed an appearance, so I'm going to continue to CC Mr. Pimenta. But that this happened after mediation and the settlement is done and over. So here, there's no question that this was after mediation had ended by agreement of the parties to impasse. And then there was an offer and acceptance, a global release, usual settlement terms. There's nothing objectionable here. No one would pay $350,000 again to settle the case, is what plaintiff requested on behalf of all defendants. And this court should affirm the decision below. Thank you.
I hope you're. Thank you.
Thank you. I'll try to move very quickly because I know I don't have a lot of time. Page 18 of the record, which is Exhibit B to the defendant's motion to enforce the settlement agreement, that contains an email from our office on Friday, February 2nd, 2024. I'm sorry, this is the email from February 6th from our office to the defense counsel, enclosing in the body of it a screenshot of an earlier February 2nd email that says, Diana, it was nice speaking with you earlier today. As we discussed, our firm represents the plaintiff and Mr. Pimenta's firm was terminated. He was notified via email February 2nd. Screenshot of that. Any further actions by Mr. Pimenta are unauthorized. As we discussed, the plaintiff disputes that there was an enforceable settlement agreement. So that right there is record evidence of a both written and oral discussion that Mr. Pimenta does not have the authority here. I specifically want to address the idea of ending the mediation. Mediation doesn't end because everyone thinks there was an impasse. It has to be an agreement, and there is no record evidence of that. Mr. Pimenta's affidavit does not state that there was an agreement to end mediation. All he says is, it is my understanding that we were at an impasse, not that we had an agreement. Ms. Kapla-Denofa's affidavit specifically says, I never reached an agreement to end. That's not consistent with the statute, which says there either has to be a report of an impasse by the mediator, or the only thing that was argued below was the parties reached an agreement. And that's the only thing that's on appeal here, is whether or not an agreement was reached, and there's no record evidence. No one testifies there was an agreement. Pimenta says, it's my belief that there was an impasse. He's silent about an agreement, and Kapla-Denofa says the opposite.
Isn't one of the ways that mediation can end is if the mediator declares an impasse by reporting to the court or the parties the lack of an agreement?
There's no evidence that the mediator reported either to the court or the parties the lack of an agreement here.
Well, if all the parties understood that they had reached an impasse, wouldn't that sort of confirm that the mediator had reported to the parties that there was an impasse?
I respectfully disagree, Your Honor. That would read out the words report to the parties. Just like he reports to the court, he files a notice of mediation results. Additionally, Your Honor asked my colleague here whether or not Florida's policy regarding settlements would be better served if we took a hard line as to when mediation ended. And I think, yes, it would, because the whole point of mediation is to have confidentiality and to have a open sharing of ideas. If in this circumstance, we could say that our final demand conveyed by the mediator is now open season and not confidential, had they not accepted it because we ex post facto believe there was an impasse, that would greatly hamper free discussion during a mediation. Additionally, the Moda case, which is a second DCA case that my colleague referenced, that case, the reason why the release wasn't a big deal is because the response, the offer was settle for a sum certain. The response was, we agree to the amount, enclosed as a release, and quote, the proposed release is not a condition of settlement, is not intended to constitute a counteroffer, and the language can be changed so that it is mutually acceptable, end quote. That's why the inclusion of a release in Moda was not a big deal, because they specifically said it's not a condition of a settlement. It didn't even have to be signed. I want to remind this court that no release has ever been drafted, but my client has been ordered
The reset.
to execute a release. If this court were to affirm, what is my client going to sign? And what rights does my client have if my client will be in contempt if they object and refuse to sign whatever onerous release is put forward to them? For the simple reason that this mediation had not ended, there's no record evidence of an agreement, which is the only basis for ending mediation that was argued below and on appeal. This court must reverse. Thank you.